the meaning of taxation cost? It can be defined as discretions on to determine the various costs and their amounts against the party whom those costs have been awarded by the court upon the resolution of the case. This taxation of cost has been governed under the Order 59 of the Rule of Court 2000. Under this order, it states that cost includes fees, charges, disbursements, expenses, and remunerations, and it deals with costs relating to High Court and Session Court. Firstly, we're gonna start with the first rule under Order 59. Under Rule 2, which on the court jurisdiction, which it preserves the right of the High Court to determine costs by virtue of any written law in respect of any proceedings before anybody, but not being proceeding in the High Court. And the next is on the Rule 3 of Order 59, which is, as a general rule, the cost must follow the event unless the court otherwise orders, and no party is entitled to costs unless ordered by the court. The third rule is on Order 59 Rule 4, which is it requires the court to take into considerations and of any offer for all contributions or offer of as improperly or unnecessarily incur costs, or even order him to pay or of the cost of the other party.
Order 59 Rule 6 of the Rules of High Court deals with personal liability of a solicitor for costs when it is incurred improperly or are wasted by undue delay. The court may disallow the solicitor-client costs, or if the client has made the payment, the solicitor must repay the client. For example, in the case of Karpal Singh against Atik bin Ali, the court held that if there was a dereliction on the part of the advocate or solicitor on his professional duties, the court may order him to be personally liable for the costs of the proceedings after giving him an opportunity to defend himself. Order 59 Rule 7 states that an order for costs can be made at any stage of proceeding. The court must direct submission of costs at the conclusion of the proceeding to deal with the costs. Besides, Order 59 Rule 9 subsection 1 restricts costs to be ordered against person who insists only the will to be proved and only cross-examine the witnesses produced in support of the will for that limited purpose. Order 59 Rule 10 allows the court to order costs due to unnecessary claims or issues to be disallowed or to be paid by a successful party where he has established a particular part of the claim.
So under taxation costs, there is also security for costs, which is governed under Order 23, Rule 1 of Rule of Court 2012. Defendant may apply for security for costs if A. Plaintiff is ordinarily resident out of jurisdiction, B. Plaintiff is a nominal plaintiff who is suing for the benefit of some other person and he or she would not be able to pay for the costs, and C. Plaintiff name is not stated or incorrectly stated in the writ or in the originating summons. Plaintiff had changed the address during the proceedings to evade the consequences of the litigation. This can be illustrated in the case of Haido Kato against Tan Tiam Chai, where in this case it was stated that if plaintiff has an agreeable case, then security for costs may not be awarded.
Procedure for applying security for costs. The defendant will apply for security for costs by filing a notice of application supported by an affidavit. The affidavit of the defendant must show that the application falls within any of the criteria stated in Order 23, Rule 1, Clause 1, Clause A till D, Rules of Court 2012. Now, the law. In the case of Kasturi Palm Products versus Palmex Industries Sendirian Berhad, it was held that the court has discretion to grant security for costs or not. In exercising its discretion, the court will consider four factors, which are the time when the application was filed, whether prior notice was given by the defendant to the plaintiff asking for security for costs, whether the plaintiff has an arguable case, and whether the application of the defendant for security for costs is to stifle a genuine claim. So these factors will be considerations for the court to grant security for costs or not.
Bullock and Sanderson orders. Bullock and Sanderson orders are each a species of cost order which may be appropriate in circumstances in which a claimant proceeds against multiple defendants.
The first order based on Bullock order whereby the plaintiff needs to pay the successful defendant cost and added cost to the cost to be paid to the plaintiff by unsuccessful defendant. A situation in which the plaintiff sued the defendant 1 and defendant 2 in the suit and later only defendant 1 is liable of being unsuccessful defendant, then thus court will order the plaintiff to pay the defendant 2, then claim the cost from the defendant 1. Thus the defendant 1 will pay the cost to the plaintiff and added to where he will pay cost to the defendant 2 also. In short, unsuccessful party had to pay for both parties. In this Bullock case, the plaintiff sued the two defendants in the suit. The court found only defendant 1 liable, thus ordered as judgment for the plaintiff against the defendant with cost. 2. The plaintiff need to pay the defendant cost, and 3. The defendant to pay the plaintiff cost which include costs paid by plaintiff to the defendant.
A Sanderson order is an order that derived from the case of Sanderson and Blake Theatre Co. A Sanderson order requires the unsuccessful defendant to pay the successful defendant's costs directly. For an example, the plaintiff sues the first defendant and second defendant for the breach of the contract. The court finds that the first defendant liable but not the second defendant. Since the second defendant is successful because he has not been made liable, and the first defendant is unsuccessful because he has been made liable, by applying the principle of Sanderson order, the court may order the first defendant, which is the unsuccessful defendant, to pay costs directly to the second